All right, y'all ready? All right, ladies and gentlemen, we're going to go ahead and get started. We do have a quorum here, and we are going to be hearing from Senator Strickland about Senate Bill 158. You should have in your folder, we are working from LC 280355S. So, Senator Strickland.
Thank you, Madam Chair, members of the committee. I bring to you Senate Bill 158, and if it sounds familiar, it's because it's very similar to House Bill 234. And I also want to give a little bit of background since you guys have already gone through House Bill 234. I thought, Madam Chair, if you'd like, I can pass it on to my colleague, talk about some of the differences in the two bills and what we kind of have here today. This bill deals with human trafficking. It's the governor's anti-human trafficking bill. I've phrased it as the next step in going after this industry in our state. And in doing this, Chairman Efstration had House Bill 234 in the House, and I filed a bill that was very similar to his, Senate Bill 158 in the Senate, and both bills went through both bodies. After that time, after both bills passed, we came together and spent the last few weeks working between each other with you as well, Madam Chair, of course, the governor's office, Representative Reeves, Mr. Boring, a lot of us trying to figure out the best bill, the best parts of both bills. And I think what we're bringing here today in the substitute, I think there might be a couple of changes we may ask you to make to the substitute, but we have that best bill that will get the signature of the governor and will be the next step in taking on this industry in our state. And with that, Madam Chair, I can hand it over to Representative Reeves if you'd like.
Okay, thank you. Floor Leader Reeves.
Thank you, Madam Chair and Senator Strickland. And again, we have with me Chuck Boring with the Cobb DA's office, who has testified before this committee before. He's a subject matter expert on sex crimes prosecutions. So what I would really like to do is narrow what I want to talk everybody through right now. Is going to be in sections 1-9 and 1-10. The rest of the bill is by and large what this committee has already passed out in House Bill 234. And on that note, section 1-9 and 1-10, conceptually, this committee has already passed this out too. Is over the last 7 to 10 days, we have been very narrowly focused on these two sections in doing what we can do to try to make sure that we have crafted this part of the bill as well as we possibly can. And so I'm just going to, the 1-9 and 1-10, which starts on page 4, this deals with the nuisance concept. And so to give some background, currently existing law, which I've got the code book in front of me right now, in Title 41, we have a section called Places Used for Unlawful Sexual and Drug Activities. And so there's currently existing law, much of which you see in 1-9 and 1-10, that establishes a structure of how either a prosecutor or a county attorney or a city attorney or a private citizen can essentially build a nuisance case against a piece of property and then take that and then have that owner of that piece of property bring them into court and have a judge make a determination of whether or not that property is a nuisance. And then if a judge is to make such determinations, and this is all existing law, and it's all here in the pages in the book that I have right in front of me, if a judge were to make a determination that a nuisance did exist, then the judge has options on different things that judge may be able to do to abate the nuisance, and injunctions that they can order, and basically ways that they can attempt to control the property such that the problem that the property is causing is under control and abated, as we would say in court. And so this is existing law. There has been an effort in the last year or two with some lawyers pairing up with prosecutors and real lawyers that are very motivated and very engaged in the fight to end human trafficking and sex slavery and all of those things, that have been using these nuisance statutes as a way to identify a place where there is human trafficking that is going on, and bringing those facilities and those places, those properties, into court under the nuisance concept of law. And so this is really an innovative thing that's been happening, and it really presents an opportunity for how we can, I think, best address some of these issues that are just frankly really hard cases to crack. And so working with those lawyers, this all started over a year ago. We began working on an effort to work within these existing statutes to clarify the procedure and to lay out a process of how we can better utilize these statutes to take care and identify these places where nuisances are happening, where it's substantial drug or sexual activity. And so what we so looking at 1-9, what we have done in this committee has already passed this concept out. But what we have done in the last 7 to 10 days is we've taken this concept, and to be honest with you, we've added a little bit of due process to it and worked within it to make sure that what we are doing is as fair as possible. So I believe the last time that this committee saw this bill, in order for, so we're gonna talk in section 1-9 now, and that is the section that deals with sexually related charges. 1-10 deals with drugs. So focusing on 1-9, the last time that this committee saw this, it was a indictment by a grand jury or an accusation. And those of you that are familiar with criminal law know that those are the two forms of a charging document. A grand jury a panel of citizens can hear from a prosecutor about a fact pattern and make a decision on whether or not to issue an indictment. And in some cases, an elected prosecutor, through their assistants, can file formal accusations, which is it's a more informal way of bringing charges as opposed to a grand jury indictment. And so as we looked into this, we really looked for a balance here. Because of the perceived informality of filing accusations, we approached this from the perspective of trying to tie those to a disposition. But the problem is that the dispositions aren't so simple that it's either a person's convicted or a case is dismissed. As over the last many years, we've created a lot of alternative ways that a case can be resolved, such as first offender or pleading NOLO or completing a diversion program or going through an accountability court. So we have.
I do apologize. With all due
am I being
respect,
too thorough?
Administrative Floor Leader Reeves, we have already heard and vetted 234,
Okay.
and we are well acquainted with the subject matter and the importance.
Sure.
I
got it. Let me. How about this? Let me just say this. We put some due process into this, and if you move over to the next page, the gist of this is that for a person that's a Did you turn my microphone off?
We took the bill you had and made it better, and I think you'll like it even better now than you liked the first time.
Does anyone have any questions?
Does this committee have a hook?
He just got it.
That message was very clear. So
I do apologize. We have to, in dealing with, very often we deal with very heartrending subject matter here in juvenile justice.
It is true, and my goal is to be thorough. It
is important to kind of maintain your sense of humor. Members of the committee, the substantive changes to the bill are basically how they deal with accusation, and that's spelled out on lines 114 through 117. And does anyone have any questions? Seeing none, what is the will of the committee? There is a motion to pass from Representative Collins. Is there a second from Representative Holcomb? Now, there are a couple of amendments.
May I? I have fear of getting my mic turned off again. Appreciate the receptiveness here. On page 6, line 163, I would like to propose an amendment to change the word separate, which is the last word on that line, to unrelated.
Okay. And as a member of the committee, you can make that motion.
So
Okay.
moved.
All right. So Representative Reeves has made a motion to strike the word separate on line 165 and instead insert unrelated. Is there a second? There's a second from Representative Holcomb. All those in favor of the gentleman's amendment, please signify by saying aye.
Aye.
Any opposed? All right. So that's the second amendment and that's the first amendment and the second one.
The second amendment is the very end of the bill on line 245. In between the words and shall, I would propose an amendment to insert any resulting conviction so that it would read, at the time of such offense, and any resulting conviction shall be considered a prior conviction.
Okay. Did you make a motion that we insert the words at the time of? I'm sorry. Would you repeat that?
Yes, my amendment 2 is to insert the words any resulting conviction to be put in between and shall in line 245.
Okay, so there was a motion by Reeves, there was a second by Representative Collins to insert the words any resulting conviction between and shall on line 245. Is there a second? There's a second from Representative Sharper. All those in favor of the gentleman's motion, please signify by saying aye.
Aye.
Any opposed? All right, so now we're back to the motion do pass on by committee substitute with those two additions and improvements from our wonderful Juvenile Justice Committee on LC 289355S. So there was a move and a second. Everyone in favor of the gentleman's motion, please signify by saying aye.
Aye.
Any opposed? Thank you.
Thank
We
you.
are
Sorry for making that overly complicated.
We are
everybody.
adjourned. Thank you.
I mean, Leader